Imagine a high-stakes spy trial collapsing, not because of a lack of evidence, but because of conflicting government messages about the very nature of the accused country. That's exactly what happened in the UK's recent China espionage case, and it's sparking a heated debate about national security, political messaging, and the limits of the law. Here's the full story, and trust me, it's more complex and controversial than you might think. The Attorney General, Richard Hermer, revealed that defense lawyers would have leveraged statements made by Conservative ministers Kemi Badenoch and James Cleverly to dismantle the case against Christopher Cash and Christopher Berry, two men accused of spying for China. But here's where it gets controversial. Hermer argues that the government's own ambiguous stance on China, often described as a challenge rather than a threat, would have been a golden opportunity for the defense. Had the trial proceeded, Hermer told Parliament, defense lawyers would have eagerly referenced these ministerial statements to argue that China wasn't viewed as an enemy under the 1911 Official Secrets Act, the outdated law under which the case was brought. And this is the part most people miss. The 1911 Act required prosecutors to prove China was an enemy, a term the government itself seemed reluctant to use. For instance, Cleverly, during his tenure as Foreign Secretary in 2023, famously declared in a Mansion House speech that labeling China as a threat, partner, or adversary was impossible, impractical, and unwise. Similarly, Badenoch, then business secretary, described China as a challenge rather than a foe. These nuanced positions, while diplomatically savvy, created a legal minefield for prosecutors. Hermer defended the prosecutors, insisting they worked in good faith, and blamed the collapse on the outdated espionage laws, which have since been replaced by the 2023 National Security Act. He cautioned against rushing to judgment, arguing that everyone involved was doing their best within their lanes. Yet, he also admitted feeling surprised and disappointed when the case was dropped, and he vehemently denied claims from the Conservatives that ministers had improperly intervened, calling such accusations disgraceful and baseless. But here's the real kicker. Hermer revealed that the Crown Prosecution Service, CPS, never sought his help in navigating evidential challenges, even though they could have. While he stressed he couldn't have influenced the evidence itself, this omission raises questions about coordination between legal and political entities. Former Labour Defence Secretary John Hutton chimed in, suggesting ministers were being complacent by blaming the collapse solely on outdated legislation. He warned that the government's reluctance to explicitly label Chinese espionage as dangerous could embolden other potential spies. Hermer pushed back, insisting the new legislation is fit for purpose and will be used whenever credible evidence of harm to national interests arises. But the question remains, can the UK effectively prosecute espionage cases when its own messaging about foreign powers is so ambiguous? And more controversially, does diplomatic nuance sometimes come at the cost of national security? Let's hear your thoughts. Do you think the government's mixed signals played a role in this case's collapse, or is this simply a matter of outdated laws? Share your take in the comments below.